why this is so funny to me. Apparently, I need to watch more court videos, bro. Okay, guys, this is called Audit the Court. He tried to use AI in court, and it did not go well. Again.
On June 19th, 2023, defendant Benjamin Lamprecht was charged with operating while intoxicated and operating with a prohibited alcohol concentration in the Burnett County Circuit Court in Wisconsin. This was...
Wait. Sorry. What's the difference between operating while intoxicating? Those sound the same.
With a prohibited... Benjamin Lamprecht was charged with operating while intoxicated and operating with a prohibited alcohol concentration.
Isn't that the same thing? Operating while intoxicated and operating with alcohol. I mean, I'm guessing legally they're like two separate, like one is, I don't know. Intoxicated can apply to more than just alcohol. Oh, thank you. One is drunk and one is having alcohol in the car. Okay, so having an open container in the car is one charge. Okay, got it. Thank you. Yes, I was so confused how they weren't the same thing.
Concentration in the Burnett County Circuit Court in Wisconsin. This was Mr. Lamprecht's third OWI offense. Mr. Lamprecht was given the opportunity to participate in the court's so-called Intoxicated Driver Intervention Program, or IDIP, which is designed to help defendants with 2 or more OWI offenses change their behaviors related to alcohol and drug use and receive impaired driving education. Participants who successfully complete the program can receive benefits, including reduced jail time, fines, and license revocation periods, and they may also avoid being placed on probation with the Department of Corrections.
Okay, so it's kind of like if they have good behavior and they're trying to better themselves, they can have a lighter sentence, or it could be shortened, that sort of thing.
The next several months, the court granted multiple continuances to allow him to complete the program requirements, which were not finished within the amount of time that was typically allotted for the program.
Bro, they gave him an extension. They're like, all right, dumbass. We are going to make it so you have more time to do the bare minimum. It's on the ground level, bro. Come on.
After rescheduling several court dates, a plea and sentencing hearing was scheduled for June 25th, 2024 in the courtroom of Judge Melissa Mogan.
Now, again, you understand that I'm not bound to follow any recommendation, and that would include following the IDIP guidelines.
Yes.
I could sentence you all the way up to the maximum possible penalty, again, if I thought it was warranted. You understand that?
Yes.
Do you have any questions for your attorney or the court before we proceed?
All right.
And that's all kinds of fun today.
Did his phone go? Bro, I get angry too easily. I'd have to change that. Like, I'd at least have, like, I don't know, anything go else in the courtroom, man. Why's it gotta be that generic ass ringtone?
Sorry about that.
I'm judging. Not just on the fact that it went off during court, but it went off and it was that ringtone.
Any questions?
Just
Whack his peep. Not really, but that's a meme. Outside of this. Things that play in my mind rent free.
one. It's just kind of a math question. I just want to know if it's fictional or a fact.
Definitely an Android phone, bro. I have an Android phone and I don't do that. Look at this girl's face. She's like, really, bro?
Kind of a math question. I just want to know if it's fictional or a fact.
Math is usually not fiction.
Yo, also, I got a math question. Sorry, my phone went off. But like, I got a question. I want to know if this math is for reals or for fiction, lady.
Why, it's math.
And yes,
It's math. It's math. What do you mean? What?
so I'd just like to be explained, like, how's math
No, please do. Please do. You have my attention. What
works. So I'm pretty good at math.
Want me to get
are you now? I have a math question. I don't know if this is for real math or for fiction math. I'm very good at math, by the way. I'm exceptionally good at math.
a math professor in here to explain it? Because I'm not a mathematician.
That's what he said.
That he's not a mathematician because he's not. Because quite honest, we go to law school, so we don't have to do math. But we have to do math in our job.
Did he try to do it? That's what he said. That's what she said joke. That was not what that was, right? Please tell me that was not it. Please do not tell me that is. Please tell me that he literally meant that he learned from the guy next to him that she did not know a lot about math. Please tell me he meant that literally and that was not.
Not because quite honest, we go to law school, so we don't have to do math. But That he's not a mathematician because he's not, because quite honest, we go to law school, so we don't have to do math, but we have to do math in our job. What's your question?
Just to know if this is fictional or factual.
I don't know what
What's the question? Spit it out. Today, Junior.
this is.
Would you like me to?
No, what is this, Mr. Keene?
Your Honor, I think it's made, the issue, and it's been up, I'm with, Ms. Anderson, is you had a question about the, grams per 100 milliliters.
Dude,
And
that's a scientific question.
I like how she just said, dude. Dude. She just said, bro, that is a science question. The fuck? I just said that I was not a mathematician.
Grams per 100 milliliters.
Dude,
And
that's
that's,
a scientific
Dude.
question. You can call up the scientists or the lab analysts that do that. I'm not in charge of that. And the legislature makes up the laws. I'm in charge of following and enforcing the laws.
Okay.
So what's your question? You think that you were below the limit, above the limit?
Bro, I respect this girl so much, man. She does not take the
This
bullshit.
guy is about as sharp as a soggy pancake.
Very true. Very true.
Beyond the limit, how they came up with the limit?
According to this, I was not above.
okay, and that's like a AI chatbot thing, right?
Yeah.
Oh my god,
Yeah.
oh my god. The guy, what is this guy representing him? Like, I feel like the guy that is supposed to help him, this is not helping his case.
Maybe it's wrong.
Yeah, it is.
An AI chatbot?
But
Are we using artificial intelligence?
it's just that I was measured in thousands, and the law goes by hundreds.
We can have a
What?
trial.
What did he said? I was majored in hundreds and is he? Did he say measured or majored?
Artificial intelligence?
It's just that I was measured in hundreds.
Measured. He was measured. Okay. He was putting emphasis on different syllables, so I had to go check.
Thousands, and the law goes by hundreds.
We can have a trial if you want.
I am so great to have a trial. I love having trials,
I love her so much. Please give her a raise. She's like, yo, I'm so down. I love trials, actually. Let's do it.
especially when the lab analyst comes, and especially when then it
Yeah, let's bring the scientist in here. It'll be such a good time. Yeah. Let's do it. I'm so down. We'll do it live.
completely opens up to the maximum penalties. That's great. And
Yeah. We can even increase your sentence if we really heighten the stakes like that. Let's do it. I'm so down.
fine with me. Is that what you wish to do, and have a lab analyst up here to explain all of the scientific reasoning behind the calculations?
Yeah. Let's bring the experts in. They'll just really fine cook you, like, to the decimal point. They'll cook you like a rotisserie chicken slowly. They'll make sure to get all the sides of you until you have nothing left to say. We will cook you so well.
Behind their testing?
She looks like my psycho ex, to be honest. What the fuck is wrong with you? Delete that. Delete that. Your psycho ex is a genius if this is her, okay? Ain't no way. Don't talk about people's looks in this video. For one. For two, she's actually so based. She's actually so based. I'm not just gonna talk smack about somebody.
Scientific reasoning behind the calculations and behind their testing?
Just take me to jail.
Okay, I think that's his way of saying he's not rushing to press the point, Your Honor.
All right. Did you review the criminal complaint with your attorney? And it
I'm really glad that he stepped in there to say whatever the hell he was trying to make out with it.
has all of those facts that says what happened that day from the officer's perspective and from your perspective, because you said, I only had 1 or 2 beers, which we know isn't factually true.
No, I had 0. I had
Bro, he was. I don't know what happened. He got possessed by the alcohol. He didn't even ingest it. It just happened. It just spiritually, he got intoxicated out of nowhere.
had drinking the night before.
So then you drank a lot more than 1 or 2 beers the night before.
Did he just say he drank in the night before? Hold up.
Had drinking the night before.
Yeah, he did. He had drank in the night before. He had drank in the night before, but not in the present of the he had the 0.
So then you drank a lot more than 1 or 2 beers the night before.
I had a
Got him. Even with that logic, she's like, yep, I'm following. So you drank more before you went to bed that night, huh?
six pack of 16 ounces and a 16 ounce.
This is where you don't elaborate. That like people will incriminate themselves every time. You don't have to argue with them. Just go with their own logic that doesn't make sense. Be like, okay, so you drank more the night before. Don't even question it. She's so good at it.
And yet you blew a .221 allegedly in the criminal complaint.
Yeah, and that's what I'm saying is that 221 is thousands, not hundreds.
Oh, Mr. Lamprecht,
Oh, Mr. Lamprecht. Oh, Mr. Lamprecht, you silly motherfucker. Oh, Mr. Lamprecht. I don't know why this is so funny to me. Apparently, I need to watch more court videos, bro. Oh, Mr.
Lamprecht. It's .08.
Oh, Mr. Lamprecht, there's no lamp on in there at all, is there? Oh, what a shame.
In Wisconsin to be legally drunk.
You sad, strange little man.
And for 1 or 2 beers or a 6-pack or whatever you said the night before, unless you are a chronic alcoholic who drinks all the time, you won't wake up the next morning to blow a .221. It's impossible.
Honestly, I wouldn't doubt that being a possibility.
Exactly.
Exactly. So true, Your Honor. Yeah, that's what I was trying to say.
But you did. And we
Oh,
have
right.
lab, right, Mr. Renicky?
We have a lab.
What does lab say? Where they tested it with scientific stuff.
Where they tested it with scientific stuff. Let's look at that science behind this.
Didn't mean to put you in a bad mood.
.19. You did by starting by being late.
I
Okay.
apologize.
You're not supposed to be late to court. Okay. You're supposed to be here early so you can meet with your attorney. And quite honestly,
Yeah. So like this stuff matters apparently in court. I learned a little bit about this. Basically, like if you want to make a good impression, it's not gonna like clear your name or something if you did something awful. But like when you go in, if you want to have good behavior and act like you care about the sentence you have, in case you guys didn't know this, you want to come in dressed nicely, like suit and tie. You want to come in on time, if not ahead of time. You want to be very well planned out, because what that proves to the jury, because they could sentence you lighter or harder, is that you care about what you did, right? Like you have regrets or you take it seriously. So if you come in late, you don't take it seriously, like you waste their time, it shows that you really don't care about it, right? So like not only is he just lying out his ass and being stupid, but he wasn't even there on time to add to it.
it's taken you months and 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 months to do the IDIP program. I gave you yet another chance. And now you're here debating
I'm just saying.
science.
Also, this is annoying because, like, okay, a lot of people don't look at it this way. I feel like, okay, maybe hot take. I feel like it's not. Her having to do this for him multiple times and wait on his ass being late and give him multiple chances just for him to be like this. She is, like, wasting time. You see what I'm saying? Like, she's basically being, like, customer service. You see what I'm saying? Like, she's got to deal with him rambling. It's like if you're a customer service person on the phone and the same guy keeps calling to complain about the same shit. It's like, goddamn, same different day.
Anytime you put a numeral behind the decimal, like 1 numeral behind the decimal is a tenth. 2 numerals.
You guys know what meme I'm talking about, right? Okay, hang on. I just have a lot of random sound things playing in my head.
Come on, you motherfucker! Ah, shit! God damn it! Same shit, different day.
Anyway.
Numerals behind a decimal is 100.
Yep.
3 decimals behind 3 numerals behind a decimal is 1,000.
Yep. I know math.
Okay, and 1,000 is 10 times less than 100.
Well, let's cut that off. Okay. You blew a .22 with a PB.
Bro, he's trying to outmath her. He thinks he's smarter than her. Are you for real? There's a lot of strategies I would have chose. But if I was him, I would have played dumb. Okay, I wouldn't have tried to play like higher intelligence. Oh my god.
T.
221.
Or 0.221, okay? So you were 0.22. We'll give you the benefit of the doubt. No more with that one, that thousandth, gone. So you blew a 0.22. But lab came back and said, guess what? We ran his blood, which is more accurate. And
So my favorite thing about these people is the best way to win an argument with them is just to follow their own logic because they're probably not using any. So when you get to their conclusion, it won't make sense. Like their own logic won't end up checking out, which looks a lot more damning than denying what they're saying. Cause like maybe they could argue like, you know, whatever type of semantic. But if you just say, okay, you're right. Let's say you're right entirely. It still doesn't work.
it gave us a better truth of what happened. And it was 0.19. It's 0.08 in Wisconsin to be legally intoxicated and operate. So you get it now? You understand now?
I don't understand how 1,000.
Yeah, he was up in those numbers, brother.
100.
Jesus.
Based on his AI research, Mr. Lamprecht argues that his blood alcohol concentration, or BAC, was not over the legal limit because his BAC was measured in thousandths, and the statute setting the legal limit uses hundredths.
Okay, but then you could just literally convert it into that other fraction and it would still be illegal, brother. You could put it in millions, you could put it in decimals, you could make it a fraction, you could put it as a pie chart, but it's still going to be like the same number.
This argument demonstrates a fundamental misunderstanding of basic mathematical principles.
Oh my God, brother. Send it back to second grade. Jesus Christ. Jesus Christ!
In decimal notation, each digit to the right of the decimal point represents a fractional part of one whole, with tenths in the first place, hundredths in the second, and thousandths in the third. The more decimal places that a number has, the more precise it is. For example, 0.221 means 2.
Oh my God, so he's upset because the decimal goes into the thousands. So in order for him to understand that they didn't do the math wrong or that they didn't count it in thousands, they have to take off the last decimal to still say, here's what it is in the hundreds, because bro is getting lost. Oh my God. Oh my God. So basically, because it said like 0.082, he's like, oh, they measured it in thousands. And she's like, okay, okay, we're not even going to go there. Just take the 1,000 part off. 0.08, you're still above. Like, holy.
221 thousandths, which is
He thinks it's, oh no, you're right. You're right. He thinks it's less than hundreds because the number is, you're right. He's dumber than I thought.
equivalent to 22.1 hundredths. 0.08, which is the legal BAC limit under section 340.
Like, I knew it was bad, but I didn't realize whew. Oh, he's making me feel smart, and I got a C in math at best. I was, like, barely passing grade, okay? Like, woo-wee!
40.0146M of the Wisconsin statutes equals 8 hundredths, or 80 thousandths. Therefore, a BAC of 0.22.
Yeah, he's over here like, excuse me, ma'am. I would like a fourth of the pizza because that's a bigger number because it has a 4 in it. So therefore, you must give me a fourth of the pizza instead of a third. I could tell because the number 4 is bigger than 3.
1 is not smaller than 0.08. It is nearly 3 times higher, making Mr. Lamprecht's argument grievously misguided.
In my opinion, he shouldn't be able to drive. Listen, I got no problem with dumb people. It's just like,
I cut that off. It's 0.22. It's 0.22.
No, if there's 3 numerals,
Yeah, I
because
think
if it was point,
Mr.
If
Renicky,
it was-
I'd love to have a jury trial because it sounds like he doesn't understand the science and he wants to have a lab analyst here.
yeah, somebody else can do this for him. I don't get paid enough, and I already did double overtime for this motherfucker.
Is that right, Mr. Keen? Is that what I'm hearing? He wants to have a jury trial because we can facilitate that next week.
I'm just saying what math.
I had a
is.
jury trial come up, not next week, the week after. We can get a jury trial. Is that what you want? You want to fight that issue of this extra thousandth in the decimal point?
It's not an extra thousandth, though. It's a thousandth or it's not.
Okay, it's a thousandth or it's not.
Yes.
You want to go to trial over that and have the lab analyst explain it? Because I'm going to
She's like, I can't. I told you why this didn't work. I can't rephrase it another way to get it to go into your noggin. So if you want an expert to come in and tell you exactly all of the very mathematical things about it, he can, all right?
tell you, she is far smarter than I am.
Yeah, you will just get char grilled, okay? Like we gonna turn it up and cook you. We're gonna flame broil you. You thought you were simmering, but now you're just going to like a steaming boil.
When it comes to science and to explain it to you. then maybe you'll be able to understand. You won't be able to
Okay,
ask her questions.
How about,
Oh, wait, is that how it works? So if somebody comes in who's an expert, he can't ask her questions. She just comes in, they ask her to do a job, and she just reads it off the paper then. Even better. You'll have to shut your mouth because they know facts and you don't.
can I just go to jail and I'll give you this copy?
I don't need the copy.
Okay, and then just, so give me the knowledge because I
Give me the knowledge. Please.
like math and
Here's what you
1,000.
can do to gain knowledge. Call up a lab analyst, have them explain it to you.
Yeah, I can't give you that knowledge. I'm not a lab analyst. I offered you the what?
Because that's what happens in a jury trial. And I hear it. It goes on for hours.
not
We have
trying to-
hours.
Is he drunk right now? I don't know. Like, I honestly don't know. They didn't say he was, but I mean, he could be.
Piss you off. Just take me to jail. I'm fine with that. I have the money finally at the last moment. You've been
What?
very giving, lenient with me and giving extensions. You're fair and I'm here. And I'll go to jail, get out. I got a job. And
All right.
Fine.
So are you admitting that you at least blew over a 0.08 or at least 0.08, at least blood alcohol content was in your blood at the bare minimum?
I agree that I blew a 0.221 and I agree that my blood alcohol was at 0.190.
Shit. God damn it! Same shit, different day.
Okay. All right.
I agree with those.
And so, and you agree that you operated or drove a motor vehicle in that state?
I agree to that, yes.
All right, Mr. Keen, may the court use the probable cause section of the criminal complaint to find a factual basis?
Oh,
Yes, Your Honor.
Has anyone made any threats to you, Mr. Lamprecht? Any promises for you to plead guilty to this charge? Has anybody promised you anything? Hey, we're gonna give you $1 million if you plead guilty. Or we're gonna give you some kind of benefit if you plead guilty, other than this offer of guidelines.
The only thing that I've been told was that I can get out, keep my job, keep my place, and keep my things.
Okay, so that's not a promise. Anyone threaten you anything? I'm gonna beat you up. I'm gonna take a gun. I'm gonna take a knife.
None of those.
Anybody threaten to hurt you or anything?
None of those.
Okay. You're pleading guilty with a full understanding of what you're doing here today.
Yes, I'm pleading guilty to blowing a .221 and
oh my
having
God.
blood.
Stop saying it. Stop. I'll play the meme again. Shut up. It's not more smart to repeat what you just said. She just,
alcohol content of
He's like, I plead to being just as dumb as when I got in here before you told me and corrected me because I can't be corrected because
0.190.
All right.
this isn't funny. The guy is simply confused. This is hilarious.
And you're pleading guilty voluntarily.
Yes,
Are you satisfied with your attorney's services?
I guess 5 out of 10.
5 out of 10. Has he done a good job in the fact that he's looked to see if you had defenses? Because I'm going to tell you, your argument here is crap. I don't say crap in court, it's crap.
I'm not, I'm just trying to conversate. I'm not trying to argue.
This isn't a conversate
Okay,
time, okay? This
Okay.
isn't a time to conversate.
okay,
This is a plea and sentencing
okay,
in which you showed up to court 18 minutes late.
okay. I forgot my,
And by the way, this is fair to him, right? Like, did this guy help you or was he not? Like, because it doesn't look like he's helping your case. She points that out, by the way.
money. I apologize.
Has your attorney talked to you about the case?
Yes,
And has he?
However, it is also important to know, if you guys didn't know this, attorneys can tell you not to bring up that, like he could have said, by the way, don't bring up this math bullshit. Not going to work. It's from ChatGPT. Stop. They could give you guidance, but they can't make you. You have the right to be an idiot. Ignore your attorney and their advice and just do what he's doing. So there is a chance that he told him, don't do this. There's only, like, they can guide you. They cannot force you. So if he chose to do this, even though there is proof that the attorney said, don't do that, this is what you should say, this is what you should do, then you can't sue the attorney for incompetence, okay?
Looked at everything and discussed with you everything that he's seen in discovery.
except for my one question.
All right, because he's not a scientist, but he said you can figure that out. Talk to a scientist, right?
I don't know any.
Yeah,
It-
like did he give you did he tell you that you could have a scientist come in? Did he give you resources if you wanted that, right? Like, this is what she's checking.
Mr. Keen, you said that's not a defense, correct?
And yes, and we have discussed that in basic math and other things along with it extensively.
All right. So based on this, the OWI.
She's not trying to cook him, okay? She's not. She just doesn't want to deal with the same shit different day because she's given him many chances.
Third, count one. How do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to
This lawyer's fed up. This is not the first time she's seen him, by the way. She has seen him several times. This is not like they just walked in and she just met this guy.
find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count one. Count two will be merged and dismissed with count one. A judgment of conviction will be entered today. Mr. Renicky, argument, please.
Whoa, hold on there. Intelligently might be a reach, Your Honor. He had all of the resources and all of the capabilities of not doing this. He has enough mental faculty to make his own decisions, is what's being argued.
This is kind of amazing, but in any event, this is an OWI. There was bad driving, but no accident. As the court is aware, it's a .19 BAC. This is his third OWI. He did complete the IDIP program. He still has to, at least at the time of my letter from Tessa Anderson, he had just dropped off the last $200 to complete the IDIP, but he needs to come up with a down payment for the electronic monitor as well as the booking fee. He was booked and released, so he has not set the 48 hours. Because of the IDIP completion and consistent with the plea agreement, we would ask the court to follow the IDIP guidelines for the 1-9 on a third offense, which I believe is
I don't know what he's saying here. I don't know what this all means.
$911 for fines and costs. That's a blood.
What did he do? He was intoxicated. He had open container, meaning he had booze, like in his backseat while driving. And he was also under the influence when he did a breathalyzer test. What was it? Twice the legal limit?
Draw, so there'd be a $10 blood draw, 45 days of jail, 24 months of ignition interlock, 75 hours of community service, and 24 months of revocation.
Mr. Keen.
Oh, sorry. It was
Yes,
almost
sir.
three
I
times. Yeah.
think this agreement recognizes both that alcohol use is an issue in the community. It has provided some rehabilitation needs because he has done some community service to deal with the harm to community. Although again, no accidents happened. He was, for the period of the IDIP, which is longer than normally, done by the court by a substantial factor, had to blow into a tube and verify that he was not under the influence of alcohol. He also.
Oh, okay. Sorry. I was genuinely asking this. He's asking the guy, like the TLDR, because I was having a little bit of trouble. He's talking a lot of legal jargon here. He's like explaining like the different things he's done, the things that he was responsible for doing for his charge. So what he's trying to do right now is not raise the charges higher than what he's currently on. Yeah, you're right.
As with an OWI 3, he would have a blood alcohol content restriction of 0.02, which means I'd be careful about even like non-alcohol because 0.02 is nothing for the next 2 years. And it does have the future deterrence because any OWIs after this are felonies with a minimum of 1.5 years in the Wisconsin state prison system.
So if he gets caught again, he'll go to prison.
Because OWI 3 is the last one, it's still considered a misdemeanor. So I think that although it was a painful process to get here, the court should stick with the agreement. Ms. Lamprecht has met the terms of the.
When she says that what he says, although it was painful to get here, I think he's saying, implying that he was late. Sorry, he was late. I read 0.08 in the chat. He was late to the hearing.
DIP, albeit not in the normally prescribed time. The agreement does serve.
Yeah, there we go. He's saying not within the normally prescribed time. He was late.
The goals of trying to get pre-sentencing rehabilitation done, and there's substantial deterrence to protect the community's interest because of just the fact that it's an OWI 3 and the ignition interlock provides that for 2 years, plus the substantially greater penalties on any future sentences. So I would ask the court to stick with the agreement despite the.
So he's saying, could you please stick with the agreement and not add on additional sentencing that further punishes him because like if he were to do this another time or if it were to be elevated or escalated higher than it is, then it is way worse. He will go to prison. Which is also why she said I can bring a scientist in. But they are not going to be forgiving. Like it's going to be cut and done. cut and dry, and it might actually be worse than if you hadn't.
The, less than beneficial
I'm
behaviors
pretty sure, okay? Take some of what I say with a grain of salt, because I am not
at
a
times
legal expert.
exhibited by Mr. Lamprecht.
Thank you, Mr. Lamprecht. Anything you want?
She's saying, like, I know he was a little ass and came here late and then argued with you about math that was not really mathing, but, like, could you please take it easy on my boy here? He has done some community service, and he will be absolutely cooked and obliterated if you up the sentence from what it is right now. So if we could just stay with the original sentencing for being guilty and not anything higher, that would be so great. Yeah.
Want to add or say to the court?
Yeah, he's saying, like, no additional damage was done, even though he's being a little ass. So, like, if we could just have him go on the course for being guilty and doing the stuff that he would have done, like more community service and like making sure not to drink and stuff as before, that would be great.
No, nothing I haven't already.
Well, I mean, what are you doing employment-wise and stuff that you're trying to help the community?
Yeah, I have a job.
Okay.
He has a job, he has a life, he
Yeah.
is there waiting for him after he's done here
Yeah.
today, which is all a positive thing. It's all about rehabilitation. OWIs are very serious. I don't make the law. The legislature makes the law. I don't determine the science. The lab analysts who go to school for years and years and years and years and years, the lab analysts, they learn science and they learn how to read scientific data. So
Yeah, she's like, I just fucking work here. My job is to determine like what I already know here and what's on the paper. And all this other stuff you want, like those are other people if you want to call them in, but they're probably not going to help you.
they are
It'll make it
the
worse.
smarter ones in the OWI matters. I know the law, I see the law, I read the law, I enforce the law. I ensure that that the community is protected in certain ways. OWI is again serious. You're putting yourself at risk. You're putting others at risk. The fact that you blew a .221 had blood alcohol content from blood at 0.19 is serious, especially given
190. Sorry for interrupting.
Excuse me. Actually, 190. He did it again.
Same shit, different day.
Don't interrupt me again. You interrupt me again and I will hold you in contempt. I will hold you in contempt and I will ensure that you have more jail time than what's being sentenced here today. All right?
I like you and you're a fair judge. I'm not trying to piss you
Then
off at all.
stop talking.
Me, when I try to tell a chatter, he needs to quit.
I need to ensure that the public
Check yourself before you wreck yourself, sir.
is going to be protected. And that means to ensure that you've learned a lesson, you're rehabilitating, you've done the IDIP program. That's a positive program. It's taking you more than most to do that program, but you've at least completed the program, which is positive. You're going to have the ability to get your license back or get an occupational prior to the end of your revocation. Your attorney is very correct. The next OWI will be a felony. The one after that is mandatory minimum prison sentences. So it's very important that you figured it out now and that you're not going to engage in this type of behavior before or again.
Judge Mogan explains to Mr. Lamprecht that if he is convicted with a fourth OWI, it will be a felony offense.
Yeah, which is also what the attorney said, which is why he said, hey, like, I know he was late. Again, this is the fourth time. Okay, so like, if this is escalated, essentially, if this goes further, right, the thing above this is prison because of how many times he's had this happen, which is why the person who came in with him, the attorney, was like, hey, I know we were late and I know it's been a little rough around the edges, but, we would like to just, plead guilty for what we have and try to serve that sentence because he's trying to de-escalate any additional charges that he could have.
Under Wisconsin law, the penalties for operating while intoxicated.
He has 3. He has 3 and 4 is a felony. But like if somebody else comes in, like the scientist, let's say, and they find out it's worse, like he actually like was way more negligent. They can escalate things. I don't know exactly like what things make it escalate, but essentially you can make it worse. If they call in a scientist and they find out like he blew an even higher amount or he was even more negligent or like there was proof of like other stuff that they looked into because they paid the scientist and they found out even more than they found out before, like maybe he was drinking or he came in drunk that day, right? It can occur, like, it can incur additional things. It can escalate.
Increase sharply with each subsequent offense. The first 3 convictions are misdemeanors, with increasing fines and jail time for each offense. However, under Section 346.65 of the Wisconsin statutes, a 4th OWI is classified as a Class H felony, punishable by a minimum fine of $600 and at least 60 days of imprisonment. In addition to these criminal penalties, a felony conviction can also carry lasting collateral consequences, such as
So like if you have a felony, you will have a really, really, really hard time getting hired anywhere. Like everything's on your permanent record, but a felony like will literally just disqualify you from several jobs.
the loss of certain civil rights, restrictions on employment and housing opportunities, and limitations on firearm possession. This escalation in penalties reflects the state's intent to treat repeat OWI offenses as serious criminal conduct, marking a clear distinction between misdemeanor and felony-level drunk driving.
What I will do is I will follow the IDIP guidelines, despite
The prison was always 1 year minimum, no. So that prisons can make money. Oops, I wasn't supposed to say that. I don't know, man. There's all types of arguments to have because, like, I also feel like it's expensive to operate prison. I don't know.
all of the issues in this case. I'm going to follow the IDIP guidelines. I'm going to assess $1,911 in fines and fees with an additional $10 blood draw fee, 45 days in jail, 24 months of ignition interlock device to be placed on any vehicle you drive. Doesn't mean you need to own that vehicle. If you're going to borrow your mother's vehicle to go down the street to the gas station, it must have the IDIP in it, or the interlock in it.
Yeah, so he's like basically getting more highly monitored.
Or you may not drive the vehicle. 24 months of revocation of driver's license, OWI assessment and driver safety plan, 75 hours of community service. If you wish to convert the 75 hours to additional jail time, you can do so. Talk to Ms. Anderson. She will ensure that the court gets a letter and you must pay for it's an additional 8 hours of community service for 1 day of.
I think for profits, guys, I don't give a shit about whether you feel like prisons make enough or not enough money. This guy is an idiot and he's driving under the influence. All right, like let's not get lost in the sauce here. We don't need to have like a debate. All right, this guy is dumb and he should be locked up regardless.
Jail time. So it's an additional $18 a day that you would need to pay if you wish to convert any community service to additional jail time. Immediately report to jail. And
I feel bad for this guy, but he's not a victim. I wouldn't. Why do you feel bad for him? He had multiple times to turn this around. He literally chose to drink and get in a car.
That means that you will have to go sit 48 consecutive hours before you are eligible to be released on monitor. I'm going to tell you, this is where I'm going to be very clear with you, Mr. Lamprecht. I take no excuse. If you are going to be released on monitor, you must prepay at least 30 days in advance. If you are even 1 day late on payment for a 30-day advance, you must sit in jail. You don't get additional time. This is where I'm very serious. You blow even a 0.0000001 with anything with alcohol. That's a violation to me. You will be immediately terminated off of the monitor. You will immediately report to jail and you will sit the whole sentence. No good time, no Huber. I was near rubbing alcohol. I ate bang bang shrimp. Okay. I take no excuse. It is an immediate.
That was really specific. Like, why bang bang shrimp?
Report. No good time, no Huber.
Judge Mogan sentences Mr. Lamprecht to 45 days in jail and explains that if he serves 48 consecutive hours in jail, he can be released on electric monitoring for the remainder of his sentence. However, if he consumes any alcohol, he will be considered in violation of the terms of electronic monitoring and will be incarcerated for his full sentence with no so-called good time and no so-called Huber. Judge Mogan's reference to quote-unquote no good time means that Mr. Lamprecht would not receive any sentence reductions for good behavior, a privilege that sometimes times granted
Oh,
under Section
okay.
302.43
I didn't even know
of
that.
the Wisconsin statutes, which allows inmates to earn time credits in order to shorten their confinement. Similarly, her statement of quote-unquote no Huber refers to Huber law privileges under Section 303.08 of the
Didn't know that
Wisconsin
either.
statutes, which allow certain inmates to leave jail for work, treatment, or child care purposes. Losing those privileges means that Mr. Lamprecht would remain in jail continuously until his sentence is complete.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, a civil judgment will be entered against you. You will also need to, you could sit up to 6 months in jail for that. I watch. I make sure that the money is paid. If it's not paid, it may result in an additional 6 months of incarceration. So ensure that you make your payments. When are you going to pay off the entire $1,921?
I have enough for the monitoring and the jail fee at this time.
$150 a month, you must start paying. I'll give you a little stay until August 1st, but then in August, you must make your first payment at $150 a month until that's paid off in full. Again, if you miss one payment, a warrant will be issued. You could sit up to 6 months in jail. It's very important that you make sure you pay 20 days to appeal. Should you fail to appeal within 20 days,
Oh,
you
wait,
do
is she
lose
saying he has to pay for his own tracker? Is that what she said? It makes sense, right? That's interesting, though. I didn't know that.
that right. Report to jail immediately. Your DNA is ordered. They will take
Damn, $1,900. God damn. Those are expensive.
that. You can request it be expunged through a written letter to the Department of Justice. Mr. Renicky, what am I missing?
I think you've covered it. Thank you.
Mr. Keen?
You aren't, not on that, but I did have a couple of items. One is, and which didn't get filled out, if he has the opportunity while he's sitting to fill out the petition for half-price ignition air lock, if he qualifies, can he submit that to the court?
He can, I'm not gonna give him time to do it. He's gonna go report to jail.
Right, understood that,
She's like, nah, you go straight to jail.
understand. And then the other item is one I filed way back in October, and you at the time rejected the proposed order and what, and so could you?
To waive fines and fees?
Well, it's to reduce the fees by the amount paid for the alcohol assessment and the driver safety plan if they're provided to the court. And the 10th Judicial District, I will admit it varies by court. Like Douglas County does it, Barron has it.
Want me to waive?
What it would be is like, he has that fine of 1,900 and some bucks. What the statute allows, if the court grants it, is to have the amount of the fine reduced by Mr. Lamprecht providing receipts to the court for the assessment
I'm
and driver
denying
safety.
that.
fund.
No,
Okay.
I don't do that.
Yeah, he's asking probably because this guy is short on cash, especially if he's still drinking. I think most of you guys could probably guess if you don't know somebody who's addicted to like alcohol or nicotine that this is not this is not a cheap addiction to have. So he's probably seeing if there's any way he could cut the cost for him.
And so you can understand there's not much that can be waived. There's a lot of mandatory surcharges in there. And when you go through it, really, because I've had really poor people that have asked, can I just do community service with the ones that that cannot be waived? There's not really that many that can be waived. And plus, this is a punishment. That's part of the punishment.
Yeah. If you waive away some of the punishment, people may not like understand the severity of like what they did, right?
And so I see it as a punishment, and that's why the legislature has increased and they continue to increase these fines and fees. It's to say, don't do it again. Don't do it again.
Being a drunk is the cheapest addiction ever. Why are you guys trying to argue with me? So
And
smart.
so,
My
no,
bad.
I'm denying.
I'm
that
learning
motion.
today.
Yes, sir.
Thank you. Ms. Atkinson, ensure that he gets and reports to jail immediately. You may.
Can I make a couple phone calls?
That's up to the jail.
Yeah,
Due
today
to
we
his-
learned on Rosie's stream that like we could start being alcoholics today because it's the cheapest hobby to have. It's the cheapest addiction to have, and yeah.
His guilty plea during this hearing, Mr. Lamprecht was convicted of his third OWI. In addition to the jail time and fines, Mr. Lamprecht's driver's license was revoked for 24 months, and he was required to install an
Oh
ignition.
yeah, and actually, guys, you thought that you couldn't work drunk, but you can. Okay. Yeah, you guys heard it here. I'm so sorry. I didn't think of a functional alcoholic, guys. Don't worry, you can start your functional alcoholism today. Yeah, if you work hard enough, you could be like this guy. He's having a great time. And then I can watch a video about you.
interlock device in his vehicle for that same period. However, Mr. Lamprecht was charged again just weeks later for continuing to drive while his license was revoked. The first incident occurred on July 31st, 2024, and the second followed on August 12th, when he was also accused of violating the ignition interlock order that had been part of his earlier sentence. Over the next year, the two cases moved together through Judge Mogan's courtroom, with several delays and warrants issued after Mr. Lamprecht missed multiple hearings. In October of
And then he doesn't sign up.
2025, the cases were
Or sign up, sorry. He doesn't show up to court.
issued after Mr. Lamprecht missed multiple hearings. In October of 2025, the cases were resolved when Mr.
They should tow his car at this point. Okay, chat, this is my theory. It's a game theory, though. I don't know anything about legal stuff, okay? Some of you might think, why don't they tow his car? The reason why is if you tow his car, then he's just going to find another way to get a car. Right? He's going to borrow a car. He's going to steal a car. So, unironically, the easiest way to catch someone trying to disobey orders is to let them keep their car and just have a monitoring system on it. Because if they're going to try to go out of their way to drive, whether or not you take away their license or you take away his car, they're still probably going to try to disobey the order. So, it's better that they have an easy way to know the interlock isn't a monitoring system. Yes, it is.
Mr. Lamprecht pled guilty to one count of driving with a revoked license, and the remaining charges were dismissed, but read into the record at sentencing. This
We get 24 minutes into a video. We just look at how he got in trouble because he tried to use the interlock system while being under the influence and got caught twice. For somebody to come in here to try to correct me, to tell me the interlock system is not a monitoring system. So today we've learned that the interlocking system was on his car for decoration.
hearing highlights the perils
It's called an interlock monitoring system because it doesn't monitor you, yeah.
of trusting artificial intelligence over advice from a real-life flesh and blood attorney. Mr. Lamprecht's attorney had explained to him that the incoherent argument that his blood alcohol level was not over the legal limit because it was measured in thousands rather than hundreds was not
I still can't get over that was his well, actually.
valid, but yet he chose to bring it up in court anyway. This decision
Oh,
reveals
no.
a deeper misunderstanding, not just of math, but of personal accountability. Mr. Lamprecht's unwillingness to accept
Woo-wee.
responsibility for his own actions was demonstrated before, during, and after this hearing through his multiple prior
It's demonstrated every single time.
OWI convictions, his repeated delays in completing the intoxicated driver intervention program, and his lateness to court. That same pattern of denial continued long after sentencing, when he was caught driving on a revoked license and he failed to install the ignition interlock device that was required by the court. Taken together, these actions show a consistent refusal to take accountability, despite
Oh, yeah, for sure. Oh, yeah, for sure. The fact that he brought ChatGPT to explain to her math that was not, in fact, mathing is impressive.
being given many opportunities to change course. Let us know if there's a case
I still think this guy was drunk while in court, hence his mental acuity speech and need for sunglasses. I don't know if do they do a breath test when you go into court? I wonder, if they don't, I wonder why not, especially since, like, a lot of the times it's, like, hard to tell if they're drunk or not. Like, I don't understand why they wouldn't just do that.
case or courtroom interaction that you'd like us to cover in the comments below. Thank you for watching, and don't forget to subscribe and share so that we can foster a more informed society.
I try, but, sometimes people just can't be helped. Oh my god, why did my... yes, my VTuber decided to freeze.